Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
All right, so let's move on. We're going to go on to the subject matter of hour 2 that we're into. This is case intakes and investigations. A very exciting part of what we do as attorneys, right? Is taking on a case. Do you want it? Do you want this case, right? Do you want to represent this person? Is this the type of case that's in your wheelhouse? Is this the type of case that you think you can handle, that you are qualified and have the knowledge to handle? Is this a case that maybe is better off to refer to somebody else? Is this a case that maybe you should just say no? There's lots of reasons to take a case or to not take a case and ways to go into that and decide. I may take a case that you may not take and vice versa, even if we're in the same practice area. And you know what's great? And even though this isn't a topic, but it will be in my mentorship program. If anyone's interested, let me know. Talking about referrals, because there's always cases that are going to come across your desk or in your inbox or in your voicemail that aren't right for you, but you may know a lawyer who it is right for. And that's when it's nice to establish referral relationships, because that goes both ways, right? So first of all, let's talk about evaluating a new matter, analyzing cases early on, interviewing clients, client intakes. And what I'm going to do is I'm going to have Sally talk about this at the outset, because one of the things that Sally does so effectively for our firm is he handles many of the intakes that we receive. An intake can be an email that someone sends you. Hey, I was referred by so-and-so. I've got this issue. Can you help me? It could be if you have a website and a contact form on your website that somebody submits an inquiry. It could be from some marketing or advertising you do that it comes through, maybe from a directory you're in or a local bar organization or a friend of a friend of a friend. Some way or another, cases are going to come in and you need to screen them. So Sally, why don't you give some examples of what you deal with on a daily basis and what you focus on and why you think these are good areas for everybody to consider?
This is where you really start to sharpen your skills and really start to issue spot and size of things. This is, from law school, I think it translates where you issue spot and case spot. So, originally when I started at the firm, Jason Friedman, one of the partners at the firm, handles the majority of the intakes, and he would start to make the calls to train me, and I would listen on the phone. And then it would then he would listen to me on the phone call and chime in with any questions and whatnot. And then it got into, I'm going to handle the call and call Jason with any issues or any questions to analyze thereafter. And now, I'm running a lot of the intakes and we're all thinking collectively, but you obviously want the who, what, where, when, why. And I think that my time as a prosecutor helped to investigate and build up cases is the same type of language that we need to speak when talking about civil. You have an accident, you want to know where there are witnesses, what were the injuries, where did this take place, when did it take place? You may pass over some very obvious, easy questions that would maybe determine whether or not the firm wants to take it if it's outside the statute of limitations, which are in the materials we provided. What's the statute on a wrongful death case? What's the statute on an intentional tort? What's the statute on a med mal, on a motor vehicle? All of these things have different time clocks. So if you're talking to a potential client that's talking about a 2014 accident that they're now just calling about, you could save the 20-minute phone call and know that that's probably not a case and that the statute is already told. So these things are you need this checklist running in your head. Okay, if it's a motor vehicle accident, is there a police report? And then the questions that come with that. Were there photos? Was there a dash cam? If you get hit by a FedEx truck or a UPS truck, there's probably a good chance that there's video from a dash cam. How do we preserve this? How long was this case ago to know if that video still exists? So those are things that you really need to know. If it's a premises liability defect on a street, go to Google Maps. Is it in the Google Maps? From Google Maps, from the address, are there video cameras around? Is there a police Argus cam that surveys that intersection? Maybe you could get access to it. So All of those things should be light bulbs in your head, like just a pinball machine giving you insight. And then obviously, what are the injuries to know? Is this a case that we want to handle? Is threshold going to come into play where the other side in a motor vehicle case is going to challenge or push back on the injuries that they may not meet the serious injury thresholds, and so on and so forth. So all of those things start to come into your brain to then formulate essentially the checklist, or, I'm going to do the intake and Andrew's going to say, all right, what do we got? So he's relying on me to be the first line to get all of this information to then go back to the firm to see if we want it. So
Yep.
all of that has to go into account.
Yeah, absolutely. And as a newer attorney, which conceivably you are, most of you are for tuning in on this program, you may want to be bringing in business. You should, if you can, right? So whether it's personal injury, whether it's plaintiff side, defense side, real estate litigation, landlord tenant, you need to know what type of cases your firm handles, right? What they don't. And if they don't, are there other people you can refer to? You need to know the key factors for assessing the types of cases your firm is going to handle. We have an insurance coverage unit in our firm led by Rosa Feeney. Many of you know or have attended her lectures or done one-on-ones with. She did the CPLR update for the Academy in the insurance area. And so she's screening for insurance coverage cases when someone calls and asking for our help in that. Is it the right one? Is the timing right? Are we within the right time frame in the litigation to get involved? Is it too early, too late? Who is the client? Is there a conflict? So you always need to ask those key questions. As Sally mentioned, statute of limitations are really important. We have a list of those in the materials for today, so you can see and have a reference if you're not familiar with them. But let's say it's an injury case and someone fell in a building and it was a school. Okay, is that a private school or a public school? If it's a public school in New York City, you've got to deal with the notice of claim requirements. Was the notice of claim filed within 90 days? And the person says to you, nah, I didn't know I even had a case until 6 months afterwards. I wasn't going to call anybody, and now I know. Well, that sounds fine, but that's not a basis under the law. So one of the things you have to realize, if you take the case, you're going to have to make a motion for leave to file a late notice of claim. You have to know if you're going to have success with that likelihood or not. So you may want to find out what's involved in being successful in filing a late notice of claim. So you want to ask a lot of questions first. And generally speaking, for what we do with our plaintiff personal injury cases is we'll want to quickly do an initial assessment of liability and damages. What's the underlying nature of the case? Is it an auto accident? Is it a premises case? Is it malpractice? Is it a ski accident? What is it, right? And we have to know, are we, based on what we're hearing from the fact pattern, are we going to be able to make out a liability case? What do we think? How many times have you, if you do plaintiff's personal injury law, gotten an inquiry for a slip and fall? And they call you and they say, yeah, I fell while going down this staircase. And you say, okay, well, why'd you fall? I don't know, but it's one messed up staircase, man. I don't know if the handrails are right. There's cracks all over the place. Okay, well, were you holding the handrail? Yeah, all right. Or were you not holding it? Why not? Okay. And what part? Did you fall on a crack? Did you trip, are you saying, or did you slip? I don't know. All I know is I fell, right? Well, your wheel should start spinning. They say, but I broke my arm and I had surgery and I have a plate and screws in my arm. Okay, well, then you're seeing damages are there, right? That's enough to just generally hear that. But you got to start thinking, all right, do you have any pictures? Was there video? Is there any way we can see what caused you to fall? You have to start thinking as a plaintiff, what proof do we have? Because if you show up to a deposition with your plaintiff and they're asked what caused you to fall and they say, I don't know, guess what? That case will get dismissed on summary judgment, okay? So you don't want to go through all of this only to get a dismissible case. You need to identify potential liability issues. And then what if someone says, yeah, I got hit from behind and they admitted it and it's in the police report. I was stopped sitting still. You say, well, what are your injuries? Well, I went to the ER, but, fortunately, I'm pretty okay. I think I'm all right now. But that person hit me. They're at fault. Well, if you've practiced in this area, you know about the threshold laws in New York, and you have to prove a serious injury. And this may not be a serious injury. So it may not be a case. And you may have to explain to that person why, even though they got rear ended, it's not a case. So you don't always have to make the decision, and you usually don't initially. So in the first example, we'd say, all right, can you get us some photographs of the staircase in question? Do you know if there's any video? Can you try and get some video? And then you say, get back to me with it. And then we'll further evaluate and explain why. They get back to you, then you evaluate it. If there's one big crack in the middle and they know they told the person I fell from the second step, and the second step is the only step that's uneven, and that makes sense, then they may say, yeah, that makes sense. I fell, it's an uneven step. Then you're okay to proceed with the case. But if there's nothing there, you're not going to be able to prove a case. So these are the types of things, whatever it is in your wheelhouse, you should have generally some questions that you want to ask. And then look out for some red flags, right, Sally? We've had some clients that we're not so sure if we want to take it, and sometimes it sounds too good to be true. You want to share what's happened in your experience in those situations?
Yeah, absolutely. Just recently I have an intake I'm dealing with a potential dog bite case, and the client said, I just need your help. I've already worked out a settlement agreement with the defendant. He said he'll handle it through the insurance, but I just need your help. And can you just take a lower percentage just so you could get it for me? And sending the photos, and I'm not seeing the full body, just the injury. So with AI and photographs being very interesting these days with technology, it's just hard to trust. And that's why I'd like to see the medical records and have the name married to the record, and the care of treatment is established around the time of the accident. So, and you can't be afraid to push back. And I think, just to bring it all together, in addition to the red flags, the theme of decorum maintains through that intake too, because as someone that works for a firm that's been around for almost 60 years, I wear that shield proudly. And you're a representation of the firm and of you as the advocate. And you're giving this intake an insight into how we play ball and how we handle this. Or you're letting them know you can turn them down with kindness too. Like I also let them know, if I'm not feeling good about this, say, look, we're very selective on the types of cases we take on. We've been around since 1968. We have a process in place. We like to do our homework, and we need these records. We need these things. And you let them know. I tell you the good, the bad, and the ugly. I don't just yes you to death to say yes, and I'm not kicking you to the curb to send you packing. Now, this is where also the marketing goes into play. If you do a good job on the intake, but you don't necessarily take the case, maybe that client feels like, wow, they really educated me and took the time to deal with me. I know they're not going to take my case, but maybe I'll call them in the future because I appreciated that service. So it's especially in a day and age where you're just getting on the phone, or if they're not coming to your office, it's kind of, you have to take the extra step to kind of size up the client to maintain that rapport and establish those expectations. We had another client, another dog bite, who said, I will give you a check for X amount if you get this dog euthanized. And sir, we're a personal injury firm. I don't know if I can ever make your uphold to those standards you want. And he said, well, I'm surprised that you're turning down this money. And it's just, yeah, is it low hanging fruit? Sure, but it doesn't feel good. And it's just not what our firm is about, or just the practice in general. So that may seem enticing, but at the same time, you have to think, wait, there could be red flags here. The client's never going to be happy, and nothing I say will make them happy. So why deal with this headache, especially contributory negligence? That could be a big red flag if they contributed to the negligence in some respect, and that negligence, that contribution might be the majority. Well, then you have a weaker case because it's more on the client, and you need to let them know that. So, if treatment was spotty and dates aren't just matching up, and they're coming to you because they didn't know and they filed a case, but they couldn't handle it. So all of those things go into your assessment.
Attendance code number 1 is NEW 128. That's NEW 128.
Yeah, and you raise a really good point that what we do as lawyers, we're called counselors as well. And it's super important that we educate and inform our clients, and that holds true to potential clients. So you don't have to feel like, and nor are you expected, and nor should you give, 100% knowledgeable answers to everything they ask when you don't have all the information. What's my case worth? Is this a good case? Do you think it's worth pursuing? You could say, to be honest, I can't answer that question until I look at your medical records, until I see the police report, until I see some investigative material. And then you use the opportunity to educate people when you are asking them questions and why you may or may not take a case. Many times people will call us and they tell us horror stories of other lawyers they've already called. Wow, thank you for taking time to speak to me. The other person said, sorry, it's not a case, and hung up. And I'm appalled when I hear things like that. Time and time again, we've had people come back to us who have reached out to us and we've rejected their case, but they were so appreciative of our explanation why, that they end up going with us when a new matter comes up. And so also, don't sell a bill of goods just to get a case. Many lawyers will do that. If you're defending a case and you say, oh, I can get you off out of this, whether you're saying it to the carrier or the client, or a plaintiff's lawyer saying, oh, I could definitely get you $1 million, because they think by promising that, that's what's going to get the case. But if you make a promise and you don't have all that information, what if it's $1 million injury? It's a leg off case, but you find out that, the person was a crackhead and walked out, on drugs at 2 a.m. onto the LIE and got hit and lost their leg, right? Bad injury, good case? No. Okay. So you don't take on a case just because the injuries are bad in and of themselves. You have to do your due diligence, and you have to have some comfort in who you are and in your skill set, where you don't feel like you have to bolster yourself to get a case. You have to be honest. You just do, because clients will see right through it. And again, with red flags, I once had a client, it was a medical malpractice case, and a child sustained a bad injury. And the parents were very mad. And they came to meet with me and they said, this doctor needs to go to jail. That's what we want to hire you for. And I said, well, that's not what I do. You have to go to the district attorney. You're not going to make sure that person goes to jail, then we're not going to hire you. And it was a very good medical malpractice case, probably a 7-figure case. I was like, listen, I'm sorry. I'm not going to, other lawyers were probably like, sure, we're going to work. We'll try and get him put in jail. We'll do all of that. But I wanted to be clear. Listen, there's certain things we can do and there's things we can't. So maybe another lawyer felt they could get that person put in jail. Maybe another lawyer will work to get a dog euthanized. So you have to work within your own comfort zone when you're analyzing new cases. And then you need to decide, what do you need to assess it? So generally speaking, in an injury case, I recommend getting a police report, an incident report, an ambulance report, and medical records. That's a way you can vet, and you do have a duty to vet a case, right? Before you take it on, and certainly before you start sending claim letters, and certainly before filing a lawsuit. Make sure it adds up. Don't you want to see what the hospital record says? Somebody tells us, I was hurt at the gym. I broke my leg. And I'm like, you broke your leg at the gym? Did you notify anybody? No. When did you go to the hospital? Later that night. What did you tell them? I don't recall. Right? Well, I'd like to see those records. You get the records from the hospital, and the hospital says, patient reports fell earlier today and broke leg. Says nothing about a gym. Okay. How are we going to confirm that it happened at this gym? How do we even know as lawyers? You need to do some vetting. So put the onus on the client, get me records, get me medicals. And in case some of you are curious, we will not agree to take on a case and spend money on a case unless we have some sense of validity to the case. So we will generally put the onus on someone to get the police report, their medical records, and the like before we will take on the case, unless there are other areas of reliability that we feel very comfortable with where we'll say, you know what, you're in a bad way. We'll take it on. We'll get the police report. We'll get the records. For example, the referring attorney, it's a family member of theirs, and they tell you it's my niece. She got hit by a car. She's in the hospital or was in for a month. We don't have the police report. We don't have any records. We need someone to get involved right away. There's a lot of issues coming up. Then we'll be like, all right, retain us. And then you can always put on your retainer subject to investigation. All retainer agreements should have that at the bottom. This retainer is subject to investigation. That means if you find something that may change your mind as you get into the case, that it's not laid out like the clients potentially led you to believe, it gives you the opportunity to get out of the case. All right. All right. So what are the tools once you do take on a case to help you lock it in, to make it a strong case? What are the investigative tools you have? What's the homework you can do when you're trying to determine how good a case is it? Where should we file this case? Who should the defendants be in this case? If you're a defendant, who are potential co-defendants that we can move this and shift the burden and shift liability over to? So you're always going to have to do homework before you file a case from when you take on a case. Now, initially, what we will do in almost 99% of the accident cases is we're going to want to find out if there is video footage. Most places have cameras these days. City streets, buildings have cameras all over the place. Good chances are if the accident happened somewhere in New York City, anywhere in New York City, any of the boroughs, residential or commercial, there are cameras. And what we'll do is we'll have our investigators do a canvas. We'll say the accident happened at this location, give them the details, give them a police report if we have it, go look for cameras. They will go building to building, house to house. Some may have a Ring camera on their front doorbell that may have caught it on the street in front. Spend that money. You're taking the case, look for video footage and send out initial claim letters and letters of representation. If you knew the accident happened at Costco inside, send them a letter. You represent this person. You want to know if they have video footage and you want them to preserve and put them on notice to preserve it. Sorry. Preservation letters are important to send out. These are initial things that you want to think about right away when you get the case, because most video footage after a half an hour may get erased. A lot of people, companies will have them on a loop. Could be days, could be months. So we tell that to the clients too when they're asking us, is it a good case? Well, you say you were crossing with the light, but the police report says that you weren't. So it's amazing. We've had cases. I'm going to just give one little war story here because I think it sheds a lot of light. We had a case where a man stepped off in New York City, Manhattan, like in the 50s near 6th Avenue business district. He stepped out of a building. There was a one-way street, as many cities cross streets are, right? It was a street that was heading, let's say, east. And he stepped off the curb. He looked east. He didn't see any cars going. And he started to cross in the middle of the street as opposed to going all the way down to one end. Let's say it's 54th between 5th and 6th. People in New York City don't walk all the way down if they're in the middle of the block and have to cross over. They look for cars and then they cross. Is there an argument about jaywalking? Maybe, maybe not. But the facts that we saw in the police report was that our client's decedent, he was killed, was walking between cars when a car was parking, walked right behind a car that was in the process of backing into a parking space and got run over and killed. And the defendant said, I was backing into a spot. I didn't see the person. They came out of nowhere and I backed up over them. And it was a $100,000 policy, I think. And we were speaking to the insurance company and they weren't even considering offering a $100,000 policy. They were saying, it's all your client's fault. Our client told us this. The police report says your guy was between cars, all of that. So sure enough, we get the video footage. What does the video footage show? Our investigators found it on some buildings, showed it nice and clearly. Our client walks out to the street. He looks to the way for oncoming traffic. He doesn't see any. He steps out into the street. He's about in the middle of the street when out of nowhere, a car that had already passed by him before he even got near the street, going down the road, had stopped, thought they saw a parking space, floored it in reverse, several car lanes right down the middle of the road, and took our guy out. Just took him out, ran him right over, and killed him. And it wasn't at all what the police report said. And it was flat liability. They settled the case immediately upon seeing that video. So that's one of the reasons why it's so important. Police reports, witness accounts, they're not always reliable. So always try and get video if you can. Sally, you want to say anything on this point?
Yeah, and just look, it's not always easy to size up a case because you have a vulnerable client, they just experienced something severe, catastrophic, or you have a family member that's calling on behalf of a loved one that they lost due to an accident. So as Andrew said, we're counselors and you have to be there, but you also have to be respectful of their situation, but also understanding that not only are we lawyers, but we're a business and everything is a business decision. And if we're going to take this time to invest into this case, is it the right one? So it's just really important to size it up, being mindful still of the situation, but not being afraid to ask those questions that'll help size up the client, because that's going to be a future client during a deposition. That's going to be your future witness at a trial. How are they going to stand up during pressure? And if they're being a little testy on the responses to your questions for an intake, how do you think that that's going to translate when a defense attorney whose job it is to shake things up is, they're going to take it personally and it may change their answers, which could, potentially derail the case. But if you have video, and, sometimes the case is going to be stronger than the witness, and it doesn't really matter if the witness is that annoying, because if like what Andrew just said, obviously that was a death case, but if the video speaks for itself, or an elevator drops and it's not supposed to drop, or a tree falls onto a car while someone's driving, those things just shouldn't happen. And it's not going to matter how cuckoo the client is, whether or not you can zealously advocate for your client and for your position in the case. So, in order to put the legwork in, you have to investigate the case. And I think I just wanted to share some tools that they can use when investigating. Like we said, go to Google Maps. There's also something here on the police report. Another thing that Andrew was saying is you could promise the case is $1 million, and then you get the insurance and it's a $25,000 policy, and your client doesn't have SUM, and you just told the client it's $1 million case, and you're only getting them $25,000, they're going to be scratching their head. And I'm not saying you need to lower expectations on purpose to then look like the hero on the back end, but you might need to lower expectations just because those expectations need to be managed. So on the police report, there's this insurance code here that we've highlighted in yellow. This insurance code is the insurance for the car and the driver for this vehicle. So vehicle 1, we're talking about this insurance. And then if you Googled New York State DMV insurance codes, it'll pull up that code, and you just have to search, and it may say Geico or American Transit, or it may say Progressive. And then from there, you know exactly who your insurance target is, to then have your staff send a preservation letter to say if there's any video, preserve this or whatnot. So this is your first signal or indication to what insurance carriers, which then can give you some insight. What some insurance companies, what policies they're writing. So then, the body is going to be the description. Who told the, driver 1 states to the police this, driver 2 states this. So now you're already getting into the details of who told who what, who observed what. So this is your first level to investigate. Then moving forward, in addition to Google Maps, and this was found from another colleague in the field, Dan Selinsky, who's part of the Academy, Zola, New York City Planning. This is another way in which you can use this resource to try and find prior dates to see what conditions look like on the street. So if you go to Zola, and these materials are in there, this is page 48 of the materials for today. You keep going through. So I use 28 Liberty, which is our office address. And then from here, you'll see on the next page, this cyclopedia. If you click on this icon, it'll give you more information and it'll pull you in to this, which kind of looks similar to Google Maps, but it has all of the years. And then if you click on any of these green circles, it'll then bring you to that time frame within that year to show you the condition of the street at that time. Another thing to take into account is this is from another case I had with a police car hit my client who was a pedestrian. So here's a memo book that's in the inside door of the driver of the police car that was involved in the accident. Well, when I had asked for the memo book, oh, they didn't have it at the time of their tour. Well, show the witness during a deposition, what is this here? So these are things you could look at. This is another case. This was an Uber where the passenger was in the car, an accident happened. The driver took off with our client still in the car and continued to drive her to her destination without ever stopping after the accident. Well, here's a dash cam in the rear view mirror of the car. So this is something that you're able to see and preserve that, or at least ask for it in your investigation. Here's the same photo, another angle in the car with the police car. And here's a video camera that records and is activated when the car hits a certain speed or when the lights and sirens are activated, the recording starts. Well, these are all things, you know, it's photographs, or this is from the body cam video. But if you really look at these body cam videos, they're not just throw-ins, they tell a story. And if you look through it and you go frame by frame and you look at things, those things can help bring to a further investigation, which could uncover more evidence at that time. So it's really important to use your skills and to not just, I looked at that body cam video for well over an hour, just watching it back, a 15-minute video going frame by frame. And I found the video, I found the memo book, and these were questions that I then incorporated into my case to know. So you have to put your investigative hat on, and you have to find every which way and angle that you could potentially get evidence that's going to support your case, or maybe debunk the case, and then you know that this is just not a case based on this video, and you have to get rid of the case.
All right. So lastly, on this issue, we want to talk about sort of jurisdiction and venue and options. And I saw there's a question as well. Right before we get into that, just as a reminder, you know, before you file a lawsuit, before you make decisions on what venue and drafting a complaint and what theories you're going to go on, whether it's personal injury, real estate, plaintiff, defendant, whatever it is, try and get as much information as you can, as many records, as many photos, videos, reports. Do your homework on the potential tortfeasors. If you're the plaintiff, if you're the defendant, do your homework on your client, do your homework on the plaintiff. Try and get as much information as you can. And there's a lot out there now with everything online and with AI and with social media searches and all kinds of stuff that you can find. So whether you're looking at a public records database, whether you go to the scene yourself of an accident, if it's an injury case, we like to do that. If we want to really get a real good sense of it, getting records, looking for prior notices. There's a bounty of information out there. If you have a case and the defendant, you want to know if they're going to likely have a good amount of insurance or not, right? Easy. If you have their address from the police report or from anything else, just Google it. Look at where they live. If you see a big house that comes up on Google Earth, or if you see an apartment in a really bad area of town, just apartment buildings, you know, you'll get a sense of whether you think the person may have assets or not, or insurance or not. These are things that you want to consider. So try and do as much as you can before you decide on how you're going to frame the complaint. We're not going to talk about that, framing the complaint. There's plenty of other programs we've done that you can find about that. But choosing venue is important, jurisdiction and venue. So they're two different things. And if you're recently out of law school, hopefully you have a fresh memory of it. but we've included also, I believe, some of the CPLR statutes for jurisdiction and venue, and you can look at that in the materials, and that's all part of the CPLR. Just Google CPLR venue, CPLR jurisdiction, New York. It'll give you the right numbers and what to look at. Generally speaking, if it's a car accident, you could bring the case where the accident occurred, where the plaintiff lives, or where the defendant lives, if it's in New York. And most of us are in New York. Now, if you're presented with a New York case, and that's jurisdiction, okay? Well, that's venue is where you file it. Jurisdiction is the state and the locale where you bring the case. So, for example, it's a car accident. The person is from Bergen County, New Jersey. The car accident happens in Brooklyn, and the person lives who got hit in the Bronx. All right. So, do you have jurisdiction over the Jersey resident? Well, here you do have jurisdiction because they were in an accident in New York. That gives you jurisdiction, control legally to bring them into the legal system in New York. All right. So, New York City, New York State has jurisdiction for this case because the accident happened there, even though the potential defendant lives in New Jersey. So you could also bring it in New Jersey if you wanted to, because certainly that's where the defendant lives in New Jersey. So you can always sue someone where their primary residence is or their principal place of business, regardless of where the accident occurred. Now, you could also bring the case in the Bronx because that's where the plaintiff lives. Right? So if you have jurisdiction in New York, venue is proper in the Bronx based on plaintiff's residence under the CPLR. You could also bring it in Brooklyn because that's where the accident happened. So you will have to have a discussion with yourself, with me and Sally, or with someone at your firm or your colleagues and workshop it. Would you rather be in the Bronx? Would you rather be in Brooklyn? Well, is your office on Court Street? You probably want to bring it in Brooklyn. Is your office in the Bronx? You probably want to bring it there. If your office is in Manhattan or Long Island, which is better, the Bronx or Brooklyn? Maybe potential better jury verdicts in the Bronx, but things will probably take longer in the Bronx, right? Are you more comfortable in one court than the other? Do you appear in one court regularly more than the other? These are all venue questions once you have jurisdiction. Now, what happens if you get a call from Jane Smith, and Jane says, listen, I live in Brooklyn. I was on my way to go see a friend, and I was on the Merritt Parkway, and I got hit by somebody. Can you take the case? I got badly injured. You may say, sure, I'll take the case. But then you find out that it was on that portion of the Merritt Parkway that's in Connecticut. And then you find out that the driver of the other vehicle was in Connecticut, right? When that happens, just because your client lives in New York doesn't give you jurisdiction. There's no ties. There's no way to grab the defendant because the defendant lives in Connecticut. The accident happened in Connecticut. So in that instance, you're going to have to bring the case in Connecticut or refer it to somebody who handles it in Connecticut. All right. So these are all things that you need to do your homework on. Now, are there multiple parties? Do those parties give you more options of venues and jurisdiction? Maybe, maybe not. So you need to look into that. You need to go back to your civil procedure class in law school, which most of you probably took more recently than I did. My civil procedure class, I think, was in 1993. But I still remember my professor going up on the board and putting a V and saying, all the defendants and the plaintiff have to be in different states to have diversity. If there's an overlap in the V and they're in the same, you don't have diversity. This is for diversity jurisdiction in federal court. In federal court, if an accident happens with a resident in New Jersey and the plaintiff is in New York and it happened in New York, you can file, you have jurisdiction in New York and you can choose your venue, state or supreme. You have diversity of jurisdiction because you have parties from different states. Again, these are all decisions you need to make, and it also may affect what parties you bring in. You may want to bring the case in New York, but by bringing in one extra party that may be involved, you don't have jurisdiction there in Connecticut. That could be a problem. Maybe you bring them, maybe you don't. So again, you want to look into who the potential parties are, what the jurisdiction is, what kind of potential coverage they have, because you always want to bring in parties that likely have insurance coverage. So these are things that you want to consider as far as jurisdiction and venue, okay? So I think we've covered most of it, and now let's go back to some questions. We're finishing up the second hour here. before we
Yeah,
move
Andrew,
on to the next topic. Yep, Sally?
I would just give a little plug for Lexitas and Ross Maller and his team. We, figure out who your firm uses for investigations to enhance, but it's always good. I'll send a letter to our investigative team to say, hey, this is the case we have, this is the evidence we're looking for, or, anything that you can help. Jump on the phone with them, see what kind of, services they can do, and maybe things that you're not thinking of to enhance the case or services that they provide. So it never hurts to get on the phone with the investigator or the investigation team your firm uses to square that away.
All right, great. Thank you for that, Sally. All right, so we're looking at some questions here, and I see a question from Tatiana, and thank you for telling us that you're finding this interesting. I hope you all are. We've got one more hour to go, and then you're free and clear until you see us tomorrow. So hopefully you're picking up some things of interest. Please let us know. But it looks like of the 700 and almost 50 of you there, you've all hung in there so far. So we're almost there. Grab your coffee if you need to, and let's keep going. So Tatiana wants to know, how can a newly admitted attorney choose between several appropriate venues if we don't know the practice of the courts, right? Ask people. That's what you do. You can never ask too many questions, folks. Newly admitted, practicing for 30 years. My mentorship program has had more seasoned lawyers in it over the last 4 years than new lawyers. More lawyers who've been practicing over 20 years. Because as lawyers know, you're always learning. Always, always, always learning. We don't know everything by far. And so how do you find out what's a better venue? Ask. Email me, email Sally, call us, speak to somebody in your firm, speak to somebody else who you know. You have to bounce this stuff off people because there's no necessarily right or wrong answer, okay? Litigation is much more art than science. So you have to, do your homework. You have to bounce things off of people. That's one of the reasons people like my mentorship program, a lot of solo attorneys. So when you join it, we're in small groups. You can bounce ideas off of me and others. That's why I love these CLE programs, because other people can chime in. And, I really see the Academy as a community. We're a community of 6,000 plus strong, Michelle? So there's a lot of resources here. A lot of people you can ask questions of, a lot of places to find answers. So that's what you do if you're a new attorney, Tatiana, and you'll do just fine. All right, Paul, in addition to the very helpful subject to investigation condition included with the retainer, any other similar specific conditions to include, any usual ads that you've had? I think a sample of our retainer is in the materials. So take a look through it. I mean, look, it's your retainer agreement. As long as it's legal, you could pretty much put what you want in there. But for the most part, whether it's in there or not, we are not indentured servants. You do not have to continue to work for somebody. So if you and a client in the middle of a litigation find that you are just not seeing eye to eye, and the client's case is bad and they don't want to hear it, or they're being unreasonable, or you don't feel comfortable handling the case for whatever reason, you have two options. One, you ask the client to relieve you. I guess three options. One, ask them to sign off and relieve you. And then you file a notice of withdrawal and they'll sign off of it. You could file it with the court if it's in litigation. Two, you ask them if they want to get another attorney. Tell them that you'll cooperate with the other attorney in the transition of the file and expenses. And then you do a consent to change attorney. And three, if they just are giving you a hard time and they're not doing anything and you're like, I got to get out of this case, you make a motion to be relieved as counsel. It's commonly done, and courts will almost uniformly grant those, with the exception is if you do it on the eve of something important, right? So if the filing deadline on something is tomorrow and you file a motion to be relieved as counsel, no good. I once showed up for a trial and we picked a jury and I got a great offer on a case. This was about 20 years ago. And my client was just totally unrealistic. Figure out what number the case is worth. We got twice that, but he wanted 10 times that. And when I said, no matter what, you're never going to get that. And if a jury gives it to you, the appellate courts are never going to get it. and he was being really unreasonable. So I thought the judge would help me. So we go and sit with the judge, and I'm like, Your Honor, I'm going to ask to be let out of this. How can I try a case for someone like this? She's like, sorry, counselor, you're a little late for that. You got to try this case. You picked a jury, right? Okay, I tried it. We got it resolved ultimately during trial. But the point is, as long as you don't wait till the end, it's not on the eve of trial, there's not a motion made. I see a lot of times where someone's handling a plaintiff's case, defense makes a motion to dismiss. It's a good motion. It's a shitty case for the plaintiff. And then the plaintiff's lawyer, while that motion just before, instead of opposing it, they move to be relieved as counsel. That's a bad move. And courts generally won't do that. And that's really leaving the client high and dry, right? So you don't have to worry too much about the language in your retainer. You have the right to get out of a case, but the subject to investigation is helpful. All right. How to read and understand a police report with a cover page, Alexis. Great. We have that cover page in our materials. So if you look through a police report and you'll see the one in the materials, you'll see there's boxes around the perimeter of a New York State police report. And there's different numbers on those boxes. And then there's usually numbers written in on those boxes. And then there's a cover page, which it looks like Alexis just put into the Q&A a link for, but we also have that cover page in our materials. So around the border, let's say it has numbers 1, 2, 3, 4, 5 on the right, and number 4, it says 3 next to it. So you'll look on the form, number 4 will say, who is at fault in the happening of this case? And then number 3 says the pedestrian. That's important information to have. So you need to have one of those forms available, keep it, save it from our materials or from the link Alexis put. And whenever you get a police report, you want to look at those numbers because it may not be in the narrative description. All right, Sally's sharing the screen now. All right, so there we go.
This is actually not in the materials. This is from what Alexis just put in.
Oh, okay, great.
So feel free to grab that link from her and incorporate it. But as Andrew was saying, they're giving all of these 1, 2, 3, 4, 5, 6. They all respond to something. They all relate to something. So
right. All right. So that's very helpful. So thank you for that.
Attendance code number 2 is NEW 131. That's NEW 131.
All right, Karam. Sorry that you feel alone sometimes. You say you're not an attorney, and you don't have a mentor.
No, he corrected it.
Oh, okay. But you don't have to be practicing, but for the mentorship program, it is limited to attorneys. So whether you're new or not, it is limited to what we do as attorneys. So hopefully that makes some sense. Okay, Andres, I spoke about jurisdiction. What have I done in cases where I already started a matter and identify that there's a party that's necessary, yet hard or impossible to serve because they avoided or their address is unknown? So, if you're already underway in a case and then there's another party, you could either, if you're within the time frame for what's called an impleader or third-party action, that's usually something that'll be in the preliminary conference, will be a deadline to bring in new parties. You just keep working on serving them and try and bring them in, and you can bring them in up until that deadline. Otherwise, what I would recommend is filing a separate action against that party. And then if you do get them into the case, you can move to consolidate if possible, or you just run them on 2 different tracks. That's really the best way that you can deal with that, okay?
Also, look through the Secretary of State. Maybe they're a registered agent through the state. You could serve them that way as opposed to directly. So
KG wants to know how I can talk for so long. I'm like the Energizer Bunny. I keep going and going, right?
I don't even think this was long.
Yeah, this is nothing. I questioned a witness last Wednesday by Zoom. We started at 10 a.m. and I finished at 6:45 at night. Let's just say that witness probably didn't have a good day. But yeah, when you're prepared, when you're juiced up, when it's a topic that you're familiar with, keep going, let it go. And I get to have Sally here with me, which helps that I'm not doing this alone. So I recommend that if anyone's giving long CLEs, bring a partner in crime. All right. Is the mentor program suitable to defense attorneys? Absolutely. We have defense attorneys all the time. I'd love for you to be involved. I think, frankly, I have as much, if not more, mentorship I can give, maybe not more, but as much mentorship to defense counsel, because I see a lot of things as plaintiff's counsel. If you're a plaintiff's lawyer, you deal mostly with defense lawyers. If you're a defense lawyer, you deal mostly with plaintiff's lawyers. I don't deal with a lot of other plaintiff's lawyers, fortunately, because I'd probably go crazy other than when I'm mentoring them. But like in litigation, I'm not litigating with other plaintiff's lawyers. But so, I see things that defendants do, that defense attorneys do, that young lawyers that work for defense firms in cases I have that I'm just like, no, 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 what are you doing? Come on. And I try and help to the extent I can. They don't listen. I think I can bring a lot of value to defense firms, and I'm always happy. I've lectured privately. If you are a senior person at a defense firm and you want to do a Zoom with me, a roundtable to get plaintiffs' perspectives on things or things defense firms can do better to move your cases, to resolve your cases, to dismiss cases, absolutely. So, Amanda, I'd love to have you. Let me know if you're interested, please. All right, a partner is asking, what sources are best used for legal research when you want to decide whether to accept the case or not? So technical legal research, like looking up case law, we use Lexis. Obviously, Lexis and Westlaw are the two main beasts. Google Scholar, you can find some stuff. AI now, I'm sure you've all heard that AI can give bad stuff. If you haven't heard about the federal practitioner that submitted a brief with cases from AI that lawyer didn't check, that didn't exist, and that lawyer got sanctioned and made us all look really bad. So if you use AI, which I'm a big fan of, just pull those cases, because AI is really bad with case law. They'll pull cases that really aren't being cited for what AI claims. But, Westlaw and Lexis are really great for doing your legal research. Natural language is usable now. It's really easy to search. Both of them have AI features that you can purchase, so you can start doing AI research. But then again, don't be shy to do just customary AI or Google research on cases you have. If you're curious, if someone says it was, a light tap, you can Google, how big is an impact if one car is going 30 miles an hour and the other one is standing still and gets hit from behind by the 30 miles an hour? Can you give me any examples of what that type of impact would feel like in another situation? I'd be curious what AI says about that. They may say, oh, that would feel like a linebacker tackling you from the NFL. I mean, I don't know what they're going to say, but it's fun to do research like that. I go down the rabbit hole all the time and look up everything I can. So do your research through specific legal research and just do your research in general.
And even instead to answer Jacqueline's question, just one more thing I'll add to that. Heard another CLE, even Westlaw and Lexis's AI isn't the best. Well, that's why you can use their resources of just calling Westlaw and Lexis, their help hotlines, so that you can ask them to help formulate your search based off of the parameters that you have, and then they can find it, pull cases, and then you can review those cases to see if it's on point. So then you don't necessarily have to rely on AI. You can rely on the actual staff of Westlaw and Lexis to help.
Yeah, Jacqueline is saying that she's heard that even, Westlaw and Lexis's AI isn't the best. It's not. There's nothing like good old-fashioned research, look up, find a case, find the notes, the footnotes, the case notes, Shepherd-Eyes, site check. There's nothing like good old-fashioned research. But another thing that's really good that we've been doing is if you find a similar case, go onto the docket the same way you would go with e-filing, whether it's state court or a PACER in federal court. If you find a similar case to yours or a case that's cited in a legal decision, go see if you could find that case. Because these days, because of e-filing, the motions, the briefs, everything's on there. And you could download briefs and use those cases. And you could copy sections of briefs. You can look up cases. So that's a really great way if you find a similar case to do research. So I suggest doing that as well. Rahul's asking, which legal publication by mail or online do you recommend to subscribe or remain updated? Everyone has their own legal publications. Back in the day, we used to get the Law Journal delivered to our office. We don't anymore, I don't think. Wherever you like to get your news from, you can subscribe. I think Law 360 is a big one. There's some different one out there. I have a podcast. Oh, Michelle saying gavel drop. That's it, from the Academy. Another resource from being a member of the Academy is going to give you all up-to-date information. Podcasts are good. My podcast on The Mentor, I'm always talking about stuff like this that we're listening to now. All of these CLEs turn into podcast episodes as well. So just, do your homework, keep asking, answer around.
And just as another resource as well, in addition to Gavel Drop, is we're going to be launching something in 2026 for the Academy. It's very exciting. It's called Litigation Lab, where it's a safe space where you could talk freely, you can workshop your cases, have a roundtable experience, kind of closed door, everything's confidential, and you could kind of brainstorm issue spotting, trial prep. You can do valuations of cases and what they're potentially worth in a safe space with colleagues of like-minded people. So stay tuned for that. That's coming out in the upcoming 2026 year, which is really exciting. It's called Litigation Lab. So you can really roll your sleeves up and dive into the lab.
You may even find me making a guest appearance in that lab, right, to workshop stuff through. So, yeah, that's a great resource. Carlos is asking, Carlos deals mostly with New Jersey law. Do I think my mentorship program would be helpful? Absolutely. We have people from other states every season in the mentorship program. We've had people, lots of New Jersey lawyers, Connecticut. We have one this year from California. We've had someone from Arizona, Utah. Because the skills are, we talk a little bit about CPLR stuff, but for the most part, trying cases is trying cases, whatever state you're in. Marketing is marketing. Public speaking skills are public speaking skills, right? Referrals are referrals, even more so if you're out of state and you're in a group with a bunch of New York practitioners. So I'd love to have you join the program. So please feel free to reach out to me for more information. Peg. All right. What about if a client terminates an attorney during the trial? Is that a mandatory withdrawal? You know what? I've never seen that happen. I'm curious if anybody has. I certainly have never been fired in the middle of a trial. It's almost like my cousin Vinny. I want that guy, I guess in theory you could. You could fire a lawyer whenever. It probably wouldn't be smart, because if you're in the middle of a trial, they're not going to say, all right, you get a new trial. If you have a lawyer, though, who's ready to step in and just continue on, I've never seen it happen. So, but it can be done, I guess, technically. I think the terminated attorney will definitely have a right to their time and money and prep. And if they're in trial, they probably spent a lot of money already. I find it hard to believe somebody would step in. I would never take over and jump into a trial for somebody else. So I haven't seen it happen. Sorry about that. We are not hiring other lawyers. A few of you have asked that. I appreciate that very much. It's a nice reflection that you're enjoying the way that we're delivering the information. We are not hiring anybody at this time, but thank you so much for asking. Aisha is asking, how much weightage do courts give to fact similarity between precedent in your case to hold the precedent binding? Flip a coin. Look at the U.S. Supreme Court. They used to follow precedent and they don't anymore, right? So, I'd say not much. I think generally trial court judges will follow their own, how they rule on labor law cases, how they rule on motions to compel. I think they'll generally follow themselves, what they do. But as far as anything else, there's really no rhyme or reason, I don't think, to a judge following precedents or appellate courts or not. I guess it depends on the specific case and how bad they want to help or hurt you or your client. It's not always, you can't count on it, that's for sure. All right. Chanti is asking, how do corporate counsel and in-house counsel, administrative, investigative, who don't litigate but advise, fit into our program, or these common advice tips? Look, you don't have to be a lawyer to do all the stuff that we've talked about so far, right? Paralegals are employed by many firms to do it, administrative assistants. So asking the right questions, doing the research, doing the homework. You don't have to have a law degree unless you're making an official appearance on the record, you're filing things in court, you're appearing in court. That's when you have to be admitted to the bar. But otherwise, all the stuff I've been talking about, you can do. Now, the mentorship program, we go over a lot of this stuff. But if you're not going to be trying cases, if you're not going to give opening statements, if you're not going to be presenting or need to get comfortable speaking in public, if you're not going to be marketing yourself, it may not be right for you. But if you want to learn those skills, then it is. It's really up to you. Hopefully that answered that question, Shanti.